welcome to Legally Speaking with me, Tarun Nangia. We commence the part three of our series on Justice Suryakant as Chief Justice of India, opportunities and suggestions. And I think we have one of the best guests today who's ideally suited to speak on the subject. I want to welcome Justice Sanjay Kishan Kaul. Currently, he is a leading arbitrator. Earlier, he served as a judge of the Supreme Court of India. He was a member of the all important Collegium of the Supreme Court of India. Before that, he served as the Chief Justice of the Punjab Haryana High Court and also of the Madras High Court. Good to see you, and thank you for your time.
Thank you, Tarun. Nice to see you.
Uh, Justice Suryakant has taken charge as the 53rd Chief Justice of India. And he earlier served in the Punjab, Haryana High Court, where you also served as the Chief Justice. Any memories from those days?
So, Tarun, I joined the Punjab and Haryana High Court in 2013, middle of the year. And that is the time when he was part of the administrative committee. In fact, we had a visit from Justice Sadashivam just before the opening of the court around the same time to inaugurate something. And Justice Sadashivam had received his intimation of appointment as the Chief Justice when he was in Punjab, Haryana. And Suryakantji was being part of the administrative committee from that step itself was involved. He carried a reputation over a period of time of somebody who was competent in his judicial work and ability to handle quantums. So he sat with more than one Chief Justice who presided over the Punjab and Haryana High Court for judicial work. But I think more than that, he also had some excellent administrative abilities. See, any Chief Justice of a High Court or Supreme Court, apart from the judicial work, has a responsibility on the administrative side. And the Chief Justice of India has a very large spectrum of administrative abilities. So you need a judicial competence and you also need an administrative competence to be able to handle it. It's not necessary both the things go side by side in a personality. I found his presence useful as an administrator, I would say, because he carried a good rapport with the members of the bar, as also with the bench, especially the younger members of the bar. So he used to be involved in a lot of activities where the bar had some initiatives to be taken, or there were walks to be organized, or some younger members to interact with. And that helps in easing the administrative issues from point of view of an interaction for a Chief Justice who is joined from outside. He was a person I could entrust administrative work from the beginning. I did that. And he would quickly get over with it. So on a lighter side, when I joined Punjab and Haryana High Court, I carried with me the benefits which a judge in Delhi carried. So I requested him to come and meet me and said, look, this is what the Delhi High Court judges have benefits. If you have something more, please keep it. If you want something out of it, tell me, I'll do it. Because it is my job to look after the judges. In turn, what I will expect from them is the work content and a turnover of the cases. Within 48 hours, the file was on my table and we could implement it. Starting from that, I adopted a practice of sending the Punjab judges to the Haryana districts and the Haryana judges to Punjab district. So often people used to say this will go by some hierarchy of seniority. I asked him to look after Ludhiana, which is the problematic area, and he did tell me that I'm not senior most as it's one of the bigger districts. So I said, look, it's not necessary that a Chief Justice assigns the biggest district to the senior most. He has to get his work done. And if I feel that if I'm having some issues to be addressed and I feel you have a good quality to be able to address, that work will be assigned to you. Interestingly, on my retirement, this is something he related to one of the persons who interviewed him about me. The interaction with the bar was also useful to an extent that we ultimately arranged at some stage of my tenure interaction with younger members of the bar in the auditorium. The idea was to break ice and tell them that, look, it's not as if the seniors only get relief. And if you possibly go and watch what they're doing, it will be useful to you. So he was part of that initiative to help in making sure that the younger members of the bar also feel involved. With these skills and having been in Himachal High Court after that as a Chief Justice, then as a colleague in the Supreme Court, we had a free exchange of ideas and he would give me his inputs at that time. I'm sure that his administrative abilities will come in very handy for him to, deal with the task. He also has a longer tenure in terms of almost more than 14 months. So if he puts his agenda in place, which he seems to have done already, I think he has the ability and willingness to carry it forward.
Thank you for recollecting the days from Punjab, Haryana High Court where you were the Chief Justice. Uh, could you sort of lay the path in the sense that Justice Suryakant has a daunting task, 6 crore plus pendency, Supreme Court pendency will touch 90,000. He's already said that he will dispose of matters in such a way that 50, 100 connected matters also get disposed of so that the pendency comes down. Any suggestions that you would like to give?
So, Tarun, I feel this is the biggest problem which the judiciary faces today, and which in a way affects its credibility also, is the ability to deal with the volume of cases. Now, if you take Supreme Court, for example, I'm given to understand the increase of pendency is also due to a very large increase in filing for whatever reasons. But what has to be flagged is that there are cases, as you just mentioned, of Justice Suryakant, where you can deal with the numbers because it has a wider ramification in terms of being able to finish more than one case in the Supreme Court. I also feel something which is important is that at times in anxiety to address the current problems and the current cases, the very old cases get left behind. And I think some benches must take up this task assigned by the Chief Justice to take from the oldest cases. They may not be very important cases, but they're pending cases. If that cases remain pending for 10 years, it sends the wrong signal. I also believe that if those cases are touched, many of them may fall by the wayside or may require some kind of a summary treatment rather than a very complicated hearing. The constitution benches have been addressed to a larger extent, starting from Justice Lalit creating six benches with almost five matters being assigned to each judge. So 30 of those was taken then Justice Chandrachud's tenure. So that issue is largely addressed. Of course, there are constitution bench matters pending. But Supreme Court must also deal with the routine matters, the sometimes what are called the Ram versus Sham matters, where Supreme Court in its wisdom has thought it fit to grant leave. Well, if it's thought it fit to grant leave, either it grants relief where required or dismisses them, does something with it. That's something in the Supreme Court I think will be a real challenge. I think also if there are cases pending in Supreme Court which have a larger ramification for the High Courts. For example, it should be verified as to the High Court. What are the areas of concern where High Courts feel that they're not able to dispose of cases for which issues are pending in Supreme Court? If they can be identified, then those matters can be addressed in the Supreme Court, and a number game it is lowered. Lowering the numbers is important, I feel, because it sends a not only a comfort level to the litigant, it also sends a comfort level to the judges that what is being done is something which is achievable and it's not getting out of hand. So he has rightly flagged, I think, the issue of trying to bring down the areas at different levels.
One thing that you have also been sort of a proponent of is speeding up appointment process in the judiciary, which will overall bring down the pendency. Given that Justice Suryakant has a 16-month tenure, which is longer by Chief Justice standards, at least in India, do you think a lot will get going there in the coming days?
Well, I wouldn't like to be a soothsayer in this, but certainly it requires to be done. At least we thought, some of us, and I had the benefit of dealing with the matters right till almost the last week of my demitting office on the issue of pushing the government on these appointments. Ideally, judicial intervention should not be required. But when timelines are laid down and those are not achieved, the courts, I think, have little option but to push. It's not a question of appointment of only to the Supreme Court or a couple of high courts. The issue is that whether a large number of high courts, the appointments are pending. It also deters sometimes the names being sent for further vacancies. It is also deterring. I strongly believe in young, competent lawyers, especially of the first generation, accepting the position on the bench. Because apart from the monetary angle involved, this delayed process is something which troubles them, and this is something which has also happened. Some cases have come to light which should not have happened. Let me say. And it needs addressing on the issue of how the appointment process should be carried forward. My one suggestion, which has been debated for a long period of time, but which is really a constitutional position which will have to be addressed, is that if we can increase the age of judges of the high courts to same as Supreme Court. This has been repeatedly suggested, not increasing the Supreme Court age. Equated at 65, it will give time to the other to fill the vacancies of 3 years, because by and large the appointments have a little lower or same time as the retirements. So 3 years nobody will retire and you'll get time to fill in the vacancies once and for all. Apart from the fact that this, lot of pressures and other things come on elevations, that somebody's junior has been taken, somebody senior has been not taken. Ultimately, often it's a game of those extra 3 years. And the Supreme Court will have a more free hand to pick up somebody who may have longer tenures in the Supreme Court and who are, well, let me say, for better words, more suited to deal with the nature of litigation which is pending in the Supreme Court.
Now, you are regarded as a libertarian judge, so you believe that people, until of course they are convicted, they have a right to, be set free. They have to get bailed out, and Supreme Court is saddled with a lot of bail applications. Unfortunately, it lands up in the Supreme Court. Do you think some structuring could be done there, or what is going on currently is working well?
See, I really don't see what structuring will be done. The Supreme Court has laid down repeatedly, has sent signals, but I think a collective signal must go from the highest court, which is, truly appreciated by the high courts and district courts. I remember when I was heading the NALSA and we had the NALSA meet in Kashmir, I talked to the senior judges in High Court saying that, look, what was earlier happening in the district courts, and people used to say, go and take bail from the High Court. Please don't, burden us in the Supreme Court with this. If I am finding that at least one third of the bail matters coming up are needing attention, then we have a problem at hand. I remember Justice Chalameshwar's view was that, and he had written on it, that let's not make the Supreme Court into a bail court, and high courts must be granting. But the problem is when liberty is involved and you feel in obvious cases it has not been granted, there's little option but to intervene. And I think this is an area, by addressing the high courts and the district courts in some manner, we must make sure that these issues do not go tier to tier, but are addressed at the appropriate level.
Point very well taken. And now, any observations you would like to sort of make, given that he has a long tenure in the Supreme Court, and being a chief is unlike any other assignment. It's all the pressure on one man's head in that sense.
So let me say that every chief who comes here brings his own agenda. Now, if the time is short, it is difficult to, sometimes adhere to the agenda. I personally feel that chief is ultimately a first amongst equals. And it is necessary to carry your brethren with you if you have to implement things. I think he has the ability to carry the people with him. If he carries the people with him, the task becomes so much easier, and the burden is shared. I think that a continuous process is necessary of the interaction among the prospective chief justices. Everybody knows by age who is the prospective chief justice. So if there is a permanent system whereby the prospective chief justices have a longer perspective of the whole thing over a couple of years, by maybe a greater discussion, a committee being formed of it, there will be a continuity of it rather than a single individual process and task. He has so far identified mediation as one of his priorities. And I think rightly so, because if he talks about reduction of areas and numbers, I don't think we have utilized mediation fully. Part of it, the government also has to wake up a little because the act has not been really implemented in its true sense, and many provisions need to be done. The mediation committee has not been formed. This is the Mediation Act is a baby of the MCPC, the Supreme Court Committee, when Justice Nariman I was part of it, and others, even Justice Narasimha was a lawyer nominee, and it was drawn up under the aegis of the MCPC and sent to the government. Substantive parts of that were accepted, except that we have structured it more on an independent basis. Government wants a greater control on it. But if we have to look to commercial expansions in the economic activity of the country, prompt adjudication of disputes in this field is important. So, at the smaller level, also the mediation can work. He has already started the process. He's identified cases. I'm told he's put in motion the activity from point of view of training the mediators. Of course, that has to be sometimes a more difficult task because you have to train the mediators properly. Otherwise, the output would not be so much. So that what is perceived as a 40-hour training in a modern mediation, not in a panchayat system as they call it. I don't think panchayats are mediation because that's a authority of the punch. Smaller issues can be addressed at the level. Contentious disputes can be resolved within the families, within businesses. But the government must also come on board to encourage this because ultimately government is such a large litigant. If it doesn't endeavor or accept settlement of its own matters, the task becomes so much more onerous.
Now, because Justice Suryakant is a great believer in mediation, and as NALSA head, he said that not only will I reduce pendency, but I'll give you a report card of what I have done. I'll get it audited. Do you think, as chief, he could sort of launch a much bigger program? I know we don't know if he is, but do you think that could be on the anvil?
I think the NALSA is a base. So heading the NALSA, he has started a process. As a chief, he'll have many things on his plate. And I think though the chief is the head of it, and it's a question of carrying forward what he has started in the NALSA in the direction of mediation. It was done, I think, with the anticipation that when he takes over chief, instead of you board the train running, instead of then trying to take off, which will take a few months. So he's done the groundwork for its takeoff. I think the issue will be how to execute it, and a push from the top for execution would be very helpful. I myself am a great believer in mediation. I think it offers better solutions. Not only it reduces the dependency issue, and most Western countries, especially US, from what we have learned, and England, their mediation is what has helped them to control the burgeoning volume of cases. And we can't have every case go to trial at every stage, every appeal going up, because those number of cases, it will become difficult for any system to handle, even if we increase the strength of judges.
Point very well taken. At the end, Justice Suryakant's, in a sense, the pinnacle of his career. One can't really become bigger than the Chief Justice of India. Any good wishes for him for his tenure from your side?
Well, I'll wish him a tenure where he's able to achieve what his objectives are. I'll wish him a tenure to increase the credibility of the system, to get people greater faith in the system, and also to be able to handle the very delicate issue of the administrative interaction between the judiciary and the government, at times with the firmness which is required. to see that we increase the faith of the people in the judiciary. We are all these institutions have been created for the people. That's why we exist.
Thank you. Thank you so much for taking out time for this special show on Justice Suryakant as Chief Justice of India. Opportunities and suggestions, as usual, in your suave manner, you sort of shared what you had to say. Also, rekindled your memories from the time when you were the Chief Justice of Punjab Haryana High Court and Justice Suryakant served as judge there. Now, the Chief Justice of India. Appreciate your joining us. Thank you so very much.
Thank you, Tarun. And I'll only add one thing that it is my hope that a matter of appointment which has not seen, at least judicially, the courts for the last 2 years, either proceed it further with it or close it, do something with it.
Thank you. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.